The court.
Presiding officer, Mr. Samunzala. For the state, May Lulungwe. For accused 1 and 3, Mr. Bangamavo. For accused 2 and 14, Mr. Essex. However, Ms. Ipinga is standing in for Mr. Essex. For accused 5, 6, 7, and 10, Mr. Namanje. And Mr. Gaib is standing in for Mr. Namanje. For accused 4, Mr. Kasper. And for accused 9, Ms. Gephardt. And we are ready to proceed.
Please, the court, Your Worship. I confirm my appearance for first and third accused. That is fourth and the fifth applicant, Your Worship. I'm ready to proceed.
As the court pleases, Your Worship, I confirm my appearance on behalf of accused 2 and 14. Your Worship, I stand in for Mr. Isaacs. As the court pleases.
May it please the court, Your Worship, I continue appearing on behalf of accused number 4 in these proceedings, and then by extension, applicant number 6. As the court pleases.
As court pleases, Your Worship, I appear for applicants 1 and 2. We are ready to proceed.
May it please the court, Your Worship, I appear for accused person number 9, who is the 7th applicant in this matter. We are also ready to proceed.
Yes, we can proceed.
Just for housekeeping, we have agreed with the parties that as soon as we are done with re-examination, we will just take a brief adjournment and then we proceed to the closing arguments. We have also agreed with the parties that seeing that there is a lot of counsel for the applicants, that perhaps if that is with the court, in order with the court, that at least each counsel be afforded 30 minutes, because we have also prepared written submissions, which we have agreed that there is not really a need to go into detail reading those submissions, as the court will have the advantage of going through those written heads. So that is the agreement that we have reached with counsel for the applicants. I think if they can just confirm that will be in order if we proceed in that manner.
Yes, we can proceed. Can you confirm?
Your Worship, on behalf of applicant 1 and 2, we confirm that arrangement.
May it please the court, I confirm that we will be able to make oral submissions in line with the arrangements we made, to the extent as well in respect of the time. However, our heads, we will require a bit of time to finalize those, considering that I'm still cross-examining. But we will be able to make oral submissions today, as it pleases the court.
May it please the court, Your Worship, we are equally ready to proceed to make submissions today. We will also, during the course of the proceedings, submit our written heads of arguments. As the court pleases.
Your Worship, on behalf of the 4th and 5th applicants, I confirm that we have prepared short heads of argument in support of in respect of bail application, and of course we make oral submission without going through each and every authority referred to. 30 minutes would suffice. Please go to you.
Yes, we can then proceed.
As it pleases the court. Good morning, sir.
Good morning.
Okay. Mr. Inambao, when we adjourned yesterday, I was putting to you that the applicant, Mr. Nandao, is prepared to, if the identity of the witnesses is made known to him, he is prepared to undertake and not to interfere with those witnesses if the court orders him to do so.
I did answer already a similar question, and my position remains the same. I'm here to oppose any granting of bail because Mr. Nandahos, as we have demonstrated through the evidence that we have presented, that he was very much involved in the activities which resulted in the charges he's facing.
Furthermore, the that condition, if it is imposed, it is sufficient. The condition of non-interference with the witnesses is sufficient to cater or deal with the fear of the state, whether that fear is indeed a reasonable fear in respect of interference with the witnesses.
We are not only talking about one specific ground of objecting to bail. There's various, and I did indicate among them is the complexity of the investigations. It's money laundering, and we know that Mr. Nandago himself, he was involved in the operations of the business, and we know that, you know, the charges are serious. Public interest is among those grounds. So therefore, you know, our position remains the same in that regard.
And given the circumstances of the specific charges against Mr. Nandago, a condition that he should not interfere with the investigations of the state, if such a condition is imposed by this court to his granting of bail, that condition is also sufficient to take care of the case fear of interference with investigations.
I've answered it already.
First,
It's the same with the previous question you asked.
okay. Because first I was referring to the witnesses, but if you say your answer is the same, I'll take it as such. Okay. Mr. Nandago has also undertaken under oath and is prepared to hand over his passport if he is ordered to do so by the state, by the court, sorry. And in the event that he should travel, he is prepared to do so with the permission or communicating with the investigating officer. And such a condition, sir, will take care of the fear of abscondment, if such a fear is indeed a reasonable one.
We are saying that, you know, his entity received at least petroleum products of 238 million. It is a serious offense, and you know, we are here to demonstrate that the public is concerned about issues of this nature. The offenses, you know, they are serious because of the value that is given to it, and therefore our position remains the same.
Okay. Furthermore, Mr. Nandago has also undertaken in his affidavit and is prepared to, if the names of suspects that are to be arrested are made known to him, he will particularly and specifically not have any contact with those that the ACC regard as suspects.
We have demonstrated in the evidence that, you know, the accused persons, at many a times they are related. In fact, I remember the words that we used was that the branches of the same trees. So there's no way we can guarantee, or the council can guarantee that there will be no interferences, because there are people who are related, there are people who has been doing business together, and that has been demonstrated through evidence in terms of transactions between the concerned entities.
Which council are you referring to, sir? Are you referring to me again?
That's correct.
Let's not do that, sir.
But
I'm
speaking
putting to you my client's instructions, nothing to do with me. I haven't given any guarantee to this court. So let's stick to what I'm putting to you.
Thank you very much. And I was speaking to you because you are the one reading on behalf of your client. Hence I said.
Yeah.
We must at all times maintain order. The witness is here to assess the court and not to engage in arguments with counsel. You will recall, Your Worship, the last occasion you took me to task, in fact, went to the extent of asking for a short adjournment so that we can compose ourselves. So, Your Worship, the treatment must be equal at all times.
Yes, I understand, but what the witness said is, he just said councils. It has come from councils. Yeah, he did not say yes.
That's why I asked him, which counsel does he refer to? He said it's me because I'm the one reading on behalf of my client.
Yes.
He said he's referring to me, that I cannot guarantee that my client will not abscond, which has nothing to do with me. I didn't put that to him. So the witness should really not do that.
I don't see anything wrong with that one. Yes, sir. Just answer the questions. Yes.
As it pleases the court. We'll proceed. If the court sees nothing wrong with that, I'll proceed. Mr. Nandago, I want to propose to you, sorry, Mr. Inambao, sorry, I apologize. I want to propose to you, sir, that the concept of in the public of interest also upholds or entails that the laws of the country, all of the laws, should be taken into account when we are dealing with issues of bail.
We are here in terms of the investigations upholding the very laws that the country has created. In this regards, the laws were broken, crimes were committed, suspects were apprehended, and hence we are saying it's in the public interest that the accused persons remain in custody, including Mr. Nanda, because of the very laws that this country has created, including the Constitution.
Sir, we've already had that debate that no court of law, except perhaps in your mind, has determined that crimes have been committed. That will be done at trial. Is that not so?
There are reasonable grounds. The evidence has established reasonable grounds which resulted in the charges being formulated against the accused persons. That is why they were apprehended and brought to court.
One of those laws that must be taken into account when one is dealing with the aspect of interests of the public or public interest, as well as the administration of justice, is the critical issue of the presumption of innocence that is entailed in our highest law, which is the Constitution.
The Constitution also provides for limitation of these rights when individuals commit offenses, so that they are brought to book and the courts deal with them. And this is what we have done.
Furthermore, sir, Namibia is a country where a lot of people come and do business. Do you agree with that?
I agree with that.
That would include both Namibian citizens and foreign citizens.
That's right.
Okay. So I want to propose to you that it is important that we ensure that our pre-trial procedures uphold the presumption of innocence, balancing it against the interest of justice as well as the interest of the public.
Because of those very grounds that you have mentioned, it's also important that people who commit crimes are dealt with in terms of the very laws that they have broken, and that justice process, it takes its natural course.
Furthermore, sir, because our country is open for business and a lot of people come and do business, a case such as this, which is based on contractual agreements, it's important that the people that do business are assured that before they are convicted, they will not be punished by being detained in custody.
I haven't presented any evidence, suggesting punishment. The evidence that I have presented suggests or supports that offenses were committed. Whether there are investors coming in this country, they must know that Namibians, we uphold the laws of this country, irrespective of, the status of an individual, or, it should be based on, the law is not discriminating. So we are here to uphold and enforce the laws, and this is what we have done. And those people need to know that if they come to Namibia and commit crimes, the country needs to deal with them as well.
That is cross-examination of this witness, Your Worship.
Advocate Mulunga, I think it's your time.
Thank you, Your Worship. Now, Mr. Inamba, I just have a few questions that I would want to ask clarity or seek clarity from you. Now, I'll start with questions that relate to the sixth applicant, Ms. Olivia Dunaiski. It was suggested during cross-examination by counsel for the sixth applicant that Ms. Dunaiski received a meager $10,000 in her account, and therefore that is a little amount, if I can put it as that, that would justify her being kept in custody. What is your comment?
Yes.
That would not justify.
But, Your Worship, of course, that was the question posed to the witness, but certainly, Your Worship, there was no addition to suggest that that should not be a justification to detain her. I mean, that addition does not come from me, Your Worship.
In fact, Your Worship, I'll just qualify the question, because comparison was made to a certain Mr. Connie van Wyk. Do you recall that? With regard to the amount that Mr. Connie van Wyk is charged with. Do you recall that?
That's correct.
Yes. So what is your comment?
When we are talking about corruption, we are not putting the value. Of course, the value does aggravate the circumstances, but in this regards is the conduct. We know that when Ms. Dunaiski was authorizing the supply of fuel to the value of at least 238 million, she was in her official capacity. She was exercising her authority, and therefore she abused. As far as the evidence is concerned, that is serious. It's not only in the respect of the fuel, it's in respect of the assets that were purchased, it's in respect of the fuel supply to Enercon as well. And therefore, in my views, it is serious because she was in her official capacity.
All right. There was also a question asked to you by Mr. Namanje with regard to the contract between Enercon and the Ministry of Defense. That is the agreement of 2013. Do you recall that?
That's correct.
Now, I just want to find out from you, during your investigations, were you in any way concerned with that agreement of 2013 that existed between Ministry of Defense and Enercon?
Your Worship, during the investigations, when we visited the Ministry of Defense to seek an understanding, initially we were provided with the agreement that was signed on 15 September 2022, which in terms of that agreement superseded all the other agreements that the Ministry of Defense had with Enercon. Of course, there were references to those agreements as well. But the primary agreement that the investigations had focused on was initially the agreement signed on 15 September 2016, Your Worship.
Okay. There was also a question that relates to the seventh applicant, Mr. Leo Stefanas Nandaho, that suggested that you do not have bank statement as per se for Mr. Nandaho that suggests that he received any money into his personal bank account. What is your comment?
Your Worship, we know there are amounts that Mr. Nandaho had received from Enercon Petroleum CC. Although they are not so much, we know that he was actively involved in the business operations, because yesterday when I was being cross-examined, I mentioned that he's been making withdrawals during the period of the transactions. In fact, I remember putting a value to it as far as the cash withdrawals concerned. And these cash withdrawals were happening during the period when Erongo was receiving fuel from NAMCOR. Your Worship, at least in terms of the records that we have, I know there are withdrawals at least rounding off to a little over 3 million that we could at least pinpoint to Mr. Nandaho.
All right. There were also questions, and these questions were asked by Mr. Namanje with regard to bail. I don't know if you, bail conditions, if you still recall that. You were asked a specific question that states as follows, that what would your preference be if bail conditions were imposed? Where do you prefer applicant number 1 and 2 to report? Will it be to the ACC or to the Namibian police? What is your comment around that? You had said, let me just go. Okay, you had said to ACC, but I just want you to clarify. What is your position?
Objection, Your Worship. Your Worship, now the rules that we are engaged in here tells us that the purpose of re-examination is to clarify confusion that might have been caused, if I may put it in those words, by the witness testimony during cross-examination. Now, when that question was posted by Mr. Namanje, the witness categorically and clearly answered and said the ACC. What confusion arises from that answer that my colleague wants to clarify in the re-examination? The question was clear, the answer was clear and direct. There is no confusion that arises that needs the witness to confirm or revisit that issue now in re-examination.
Yes, I have a reply. Your Worship would recall that during cross-examination of Mr. Inamba by Mr. Bangamavo, in fact, he was accused of retracting some parts of his evidence, in that he had said, well, you had agreed to that position, and it appears that there are two positions now, because he said something else, which I do not want to say because I don't want to testify on behalf of the witness. And my question is based on that, because he was being accused of retracting some parts. So I just wanted him to comment.
Objection, Your Worship. With due respect to State Counsel, he can't say, I accuse the witness of retraction. The record, Your Worship, everyone here in this court heard what the witness said. He simply retracted. So there was no accusation, there was no nothing. Because of his retraction, I put it on the record that during the submission, we invite the Honorable Court to declare this witness unreliable witness, and some of the evidence should be disregarded. That was my submission. I never accused Inambao of retraction. He retracted himself because he, for some reason, maybe was coached during the adjournment. When he came back, he started retracting and changing his mind or changing his evidence. I never accused anyone of anything, Your Worship.
Your Worship, and just to add to Mr. Bangamwabo's sentiments, assume this witness is allowed to answer that question and new evidence arises. We are done cross-examination. We will be prejudiced in challenging this witness's evidence as far as this question is concerned. But our stance remains, Your Worship. It doesn't matter what question Mr. Bangamwabo posted to this witness that he ended up retracting things or changed his things. Mr. Namanje's cross-examination question was clear, and the answer provided by the witness as far as that question by Mr. Namanje is concerned was clear. There is no confusion that arises which calls for re-examination on that issue. Those will be our submissions, Your Worship.
Yes. Firstly, the court will deal with the last aspect of Mr. Bangamwabo. It is indeed apparent from the record that counsel for the fourth and fifth applicant did not accuse the witness. Yes, that must be clear. Now, with regard to the objection, it is apparent that indeed a question was put to the witness and he answered in the manner he did, and counsel want to clarify that aspect, taking into account the last aspect referring to the restriction. Therefore, for that reason, the record is clear. The court will allow the question. Yes.
Please go to worship.
Court, please.
Sir, what is your comment
Yes,
on that?
what is your comment, sir?
Your Worship, a lot of questions were being asked. The position of investigations is that we are here to oppose any granting of bail to any of the accused persons, and I've indicated that. If I said something in regards to the question of Mr. Namanje, we are here to come and oppose bail against all the accused persons. So as far as the conditions are concerned, we are not here to agree to any conditions. That will be the duty of the court. We are here to come and oppose bail. Your Worship.
We can proceed.
Your Worship, I don't know if it's necessary, but I cannot coach a witness. I'm an officer of court, but yeah, I'll just continue.
Yeah, just proceed.
Yes, thank you, Your Worship. Now, you can just bear with me.
Take your time.
That will be re-examination. I think the other question, I'll just argue the rest. I do not have any question. Mr. Court, please.
Sir, we thank you for your time. You are excused.
Thank you, Your Worship.
The court will then take a brief adjournment. You can
Yes,
proceed.
yes, Your Worship, just before we commence with the submissions, I did not indicate that Mr. Inamba will be our only witness for the respondent. We will not be calling any other witness.
What is in
We
order?
are closing our case as well.
Yes, we can proceed.
As the court pleases, Your Worship, I stand to make submissions on behalf. Please, Marco, to make submissions on behalf of the first and second applicants. May I ask Your Worship that you, with respect, have D2 with you when I argue? Exhibit D2. Then exhibit H1, Your Worship. And Your Worship, I have managed to prepare substantive written heads of arguments, Your Worship, and may I ask my juniors to provide the court with a copy of first and second applicants' written heads of arguments. And that is accompanied, Your Worship, by a bundle on which, on top of it, there is a judgment of Major General Thomas Nopoju Hamnyera. I just want to make sure that, Your Worship, you were given that judgment. Ending at page 54. Yes, yes. So those are the, I think, 4 pieces of documents I will be dealing with in making submissions, Your Worship. I want to start with something that may not be necessary to say, but in a matter like this, which is a subject of intense public scrutiny, it must be said. And I want to start, Your Worship, with the responsibility of the court, the responsibility of counsel for defense, the responsibility of the public prosecutor towards this proceeding. First is that when the accused person comes to a criminal court, doesn't matter, it's a bail application, they come for a dispute to be determined by this court. And that court, there is jurisprudence. It must be a court that is impartial, court that is open, court that is competent, court that would not unnecessarily make judgments to appease a section of society in a manner that is incompatible with the rule of law. That is the overriding object and nature of the power of court and the expectation of those who come to court as parties, including accused person, Your Worship. In respect of the state, public officials, they are doing a very important, public prosecutors are doing a very important constitutional and statutory duty to prosecute, not on behalf of government, but on behalf of the people of Namibia. Hence, it's the state versus our clients. There is a difference. The public prosecutor prosecute on behalf of people of Namibia, including all of us. And the requirements are that when they do that, they must do it in a manner that advances the cause of justice. They are not yet there to suppress information or evidence that is in favor of the accused person. On the other hand, defense counsel find themselves in court because our founding fathers decided, and we have no choice, that people accused of crimes are presumed to be innocent until proven guilty by court. Secondly, they are entitled to have legal practitioners of their own choice. Thirdly, if they are unable to pay for a legal practitioner, the state does fund legal representation for all accused persons who are unable to pay for private legal practitioners, irrespective whether or not they are charged with high treason, with corruption, and so forth. This is because one of our foundational values of this country is justice for all. Justice for all. It is because of that that I will proceed, Your Worship, to start my submission in accordance with our heads of arguments. And I'll start as a preface to my arguments with the matter, the judgment of General Nopoju Hamnyera, the second bundle that I handed up, Your Lordship. This was one of the saddest criminal cases in our country. As Justice Shiming Chase narrating the judgment, this is a respected freedom fighter who was unlawfully and unnecessarily arrested, obviously, and subjected to a refusal of bail, have to spend 3 days in custody before being released on bail. But what we take away from this judgment, Your Lordship, in the interest of time, is that it doesn't matter who you are in society. When you come in court, you are entitled to the same protection as every other citizen. That judgment runs from page 1 to page 21, Your Lordship, for the bundle. You have seen that the High Court awarded damages to General Nopoju Hamnyera, and there are strong sentiments by the High Court in the manner he was treated. It's history that initially he was charged with corruption. That case kissed the dust. Again, he was charged with bogus charges of theft of stock. Again, those charges kissed the dust, and he was persecuted through court proceedings and was unnecessarily arrested. Now, then there is a judgment at page 22. That is to Afeni Simon, Your Lordship, versus the Minister of Home Affairs. And the only important paragraph that I want to deal with is the one at page 31, Your Worship. And this is where we start in a matter like that. No person shall be deprived of personal liberty except, and that is important, Your Worship, except according to procedures established by law. And then over the page, no person shall be subject to arbitrary arrest or detention. And then the judgment speaks of presumption of innocence. And over the page, Your Worship, at page 35, Justice Waitere then referred to that an arrest must be necessary. Your Worship, if you look at the first sentence, that start to be lawful, it goes on and says an arrest must be necessary. I want to make one thing clear, Your Worship. These are not proceedings to attack and arrest. This is a bail application. But whether or not an arrest was necessary in the first place is a relevant consideration in a bail application. It is for that reason that we refer to that judgment. The next judgment, Your Lordship, in the interest of time, I will be referring to the Hairuru judgment at a later stage. Let's then move to our heads of arguments and start demonstrating that the two applicants exceedingly proved that they are candidate for bail. At page 1 of our heads of arguments, Your Worship, we start with a quotation taken from the case of S versus Heller and another, 1964, volume 1, South African Law Report, page 520 at 535. The quotation is, "It may be that the accused were guilty of some breach of duty, diligence, or good faith towards the particular company, and so liable for negligence. That, however, would only be a civil wrong, not a crime." I'm not representing an accused person who worked for NAMCOR, but in this matter, I want to demonstrate that even assuming that there were some lapses in the system, some negligence, it can never be transformed into a criminal conduct simply because, unfortunately and regrettably, public money has been lost. And you will see, in the interest of time, in footnote number 1, Your Lordship, there is another quotation that indicates one must be very careful, particularly in commercial transaction, not to transform failure of commercial transaction into criminal conduct. In the interest of time, Your Worship, I have documented a useful and contextual background from paragraph 1, Your Worship, to paragraph 19, and I leave out the rest in the interest of time. But may I invite the court to page 8, footnote number 17, where we refer to the case of KPMG Chartered Accountants. We are referring that case, Your Worship, simply to make one thing clear. Those agreements are not to be interpreted by witnesses, but by court. The agreements that are concerned, firstly, it's only the court. Mr. Inambawo has no competency, has no right whatsoever to assign an interpretation as to what the MOD or asset purchase agreements to start calling asset service stations and so forth. The agreement itself, a written agreement, is the exclusive memorial of what was agreed upon, and if there is any dispute on the meaning, that is the function of the court. I need to move with speed at page 9, Your Worship. I refer the court to paragraph 22 of our heads of argument, and we refer to a very important case. That is of Waste versus the Minister of Safety and Security. There is misconception. There is a misconception that once you are armed with a warrant of arrest, it doesn't matter you find a woman in hospital, in labor, you should effect an arrest. It doesn't work that way. Even when you are armed with a warrant of arrest, particularly where an accused person cooperated with an arrest, you must still exercise your discretion whether or not you would, in those circumstances, proceed and arrest. You see the judgment quote, paragraph 12 of that judgment, Your Worship, and I do not want to read it out in the interest of time. Then part B of our heads of argument, Your Worship, deals with the personal circumstances of the two applicants. There was no dispute about their personal circumstances, and I do not want to waste the court time. That goes up to paragraph 27 of our heads of argument. Then we start with legal submission proper at page 11, part C of our heads of argument. Now, this is where it is important, Your Worship. There are 7 subsections under C, C1 to C7. Each one, we back up each argument with legal authorities, and we start with the first controlling legal principle we are relying on. And that is that it is easy in matters in which high-profile accused appear and the proceedings are made the subject of immense publication by the media for a court to seek to satisfy public expectation. Such a scenario is not in accordance with the rule of law and legal principles relating to the independence of the judiciary. Over the page, at page 12, paragraph 29, Your Worship, Justice Liebenberg, one of the most eminent judges Namibia had ever had in the High Court, in S versus Madisia, had the following to say under paragraph 15. I only proceed in the middle of paragraph 15, which says that it should be made clear to all that what is required for this court today is to punish the accused person for the crime they stand convicted or based on the facts and the law as set out in this court area judgment, not for crimes society expected them to be guilty of. For the court to give in to public expectation as opposed to considering how public interest could be served will result in a travesty of justice. Over the page in paragraph 16, Judge Liebenberg continued, amongst others, and stated that it need equally to be recognized that public expectation is not synonymous with public interest. The rest, Your Lordship, accord to other judgments on the independence of the judiciary and so forth. I move with speed to C2, to the second principle we are relying on, and that the court must always, in all the judgments, Your Worship, you will find that there is a central theme, that is, the court always leans toward a release of an accused person on bail. Therefore, in that S versus Branco, in that case, Your Worship, you remember, it's a South African case where the court found that there was a strong case against Mr. Branco. In fact, that was, I think, 2 tons of, 2 containers of mandrax in South Africa. He was not a South African citizen. The court rejected his version on the merit and found that he has a strong case to meet. But the court granted bail. But the most important with Branco's judgment is that it relied on S versus our case on the Namibian case. And it says that the fundamental objective of the institution of bail in a democratic society based on freedom is to maximize personal liberty. The proper approach to a decision in a bail application is that the court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is clear that the interests of justice will not be prejudiced. Your Lordship, you remember now on your notes when I asked Mr. Inambao, I have greatest respect with him as an officer, but when I asked him and I heard that he was trying to retract things he considered under my cross-examination, it's not permissible. He couldn't, because I was asking him on behalf of my clients, not on behalf of every other person. So he said he did not arrest my client because they are flight risk. He did not arrest them because they would interfere. He did not arrest them because they are a danger to society. He gave no reason whatsoever how interest of justice would ever be prejudiced. So with respect to your Worship, I ask that the court have that in mind when considering the facts and the law. We move to page 14, paragraph 31. Now, judges who served in apartheid courts, of course, many of them failed in their duties to do justice because the consideration of the so-called security factors those days against organizations such as ANC and SWAPO, some of them, as soon as they saw an accused person accused of political crimes, they failed in their duty. But there were those judges who refused to be judges who were not prepared to do justice. Therefore, in the case of Arce versus Minister of Home Affairs, 2012, Volume 4, SA 544, the South African Supreme Court spoke about a long list of cases since 1879. And you will see, Your Lordship, a quotation from Judge de Villiers, CJ. Even before that, before constitutional democracy, both in South Africa and Namibia, judges on all cases on liberty, they always stated that the court must always lean towards granting bail or releasing an accused person. I do not want to waste time. That quotation is relevant and it goes over the page. And Your Worship, I do trust, and I have, with greatest respect, I have confidence that the court will, in goodness of time, read all this. But in the interest of time, I move to submission number C3 at page 15. And this is what is important, Your Worship. It is, what is that one all-embracing issue the court must concern itself during the bail application? Your Worship, to be fair to court, the court continued reminding us during this proceeding that Your Worship, you are concerned with the question of bail. You reminded us on my count more than 10 times. And you are not alone, Your Worship, because the High Court of Namibia is with you. In S versus Pinheiro, you remember, Your Worship, that was a case of some Spanish nationals who were found fishing in Namibian waters right after independence, some years after independence. That is 99 Namibian Law Report, page 18. And Justice Frank, those days, stated over the page, Your Worship, if the court can move to page 16. So he says that, in principle, the court addressed only one all-embracing issue. Will the interest of justice be prejudiced if the accused is granted bail? That is the overriding consideration. It's not a theoretical, abstract process where you simply tick off, this is a Schedule 1 offense, this is corruption, is not bestiality, it's high treason, it's murder, then you tick it off, I will refuse bail. There must be something that you found on facts in a bail application that shows you that in the administration of justice will be prejudiced. That is the main thing. And then I move with speed to before argument number C4, Your Worship, I invite you to look at footnote number 23 at page 16. Footnote number 23. Of course, I have greatest respect for Advocate Lirungwe. He discouraged me to refer to a book that I have authored, but a book is a book, Your Worship. Luckily, I referred to, and I gave up a copy, Your Worship. In that book, Your Worship, you would find a case, an old case in South Africa, where there was a warrant of arrest of somebody, but somebody came in from the UK and was arrested on arrival. Chief Justice Innes, those years, asked, and stated the following, and stated in the footnote, Your Worship, now it is quite a common thing to arrest a man who is fleeing from the country, but it is rather a remarkable step to arrest one who is returning. So in other ways, questioning the necessity of arrest when a person is cooperating. For instance, Mr. Malakia Elindi testified that when he heard that he was about to be arrested, he cooperated, he drove from a village which is about 60 kilometers to the borders of Angola and Namibia, and he came to Windhoek to cooperate with authorities. Mr. Peter Elindi presented himself to ACC. If it was Chief Justice, a good lawyer, a good jurist, as he was, who invests his soul in pursuit of justice, justice for all, he would have asked, it is an extraordinary matter and remarkable matter to arrest a man who will present himself to ACC. And then you go on. saying bail must be refused. Your Worship, we then go to argument number 4, and that is the law now in Namibia at page 16, C4, Your Worship. And that is that a person must only be arrested and remain in custody if the arrest was the most appropriate mode of bringing a person to court instead of summons, and other modes of securing a court attendance by the accused are not appropriate. Now, this is the biggest problem in our country, and it's horrifying, it's scary, the way we are going on as part of the arrest and detention system is broken, and it's only court that can fix it, because it's being abused. Let's start with the ratio and philosophy behind arrest. Your Worship, the ratio behind arrest is to bring a person to court for a trial. If people were not to interfere or to run away or to be a danger to society, like in violent crimes, there will never have been an arrest. Everybody will be invited through a notice to come to court. Your Worship, that is the ratio. So now, it's not a power that ACC or Namibian police have. So when they wake up on a bad day, a police officer just press a button, today I have to arrest somebody, I have reached this stage, even if I'm not ready to go to trial, I want to arrest a person today. It doesn't, otherwise it would be unnecessary and arbitrary. So people are only arrested before the state is ready, because they are out of necessity. They must be brought to court so that the court fixes condition, and they must be kept, because if not, something will happen to the administration of justice. So now, it's not like in this matter where you find the warrant of arrest were issued on the 3rd. The arrests are effected on the 8th and the 9th. So they could even have woke up on the 10th and arrest. There was no agency. Then comes to court, we are being told about medical reasons and so forth. And why is an officer crying in court that the state is under pressure, the charges are full of mistakes and so forth? So therefore the Supreme Court, the High Court, has now fixed that issue. In Hairuru versus the Director of Anti-Corruption Commission, the citation is 2014, Volume 1, Namibian Law Report at page 62. We quote over the page, Your Worship, page 17, paragraph 95. And I quote Justice Damaseb, again an eminent, respected member of the judiciary, says, "It is clear on this authority that it is incumbent upon an arresting officer to apply his or her mind to the question whether arrest, given its gravity, is the most appropriate manner of bringing a person before court. The obligation to do so becomes even more pronounced where the offense does not involve violence." Mr. Inambao considered my clients, if released, they are not going to be danger to society. Why arresting them? Your Worship, you followed when I asked Mr. Inambao, what was the trigger event for arrest? He never told you. He never told you, Your Worship, what was the trigger event. And Your Worship, in the interest of time, the last paragraph 97 of Hairuru judgment, then Mr. Damaseb Justice Damaseb states, "I'm satisfied that the applicant has made out a case that the respondents, those are ACC agents, failed to apply their mind to whether or not it was necessary to effect an arrest." So the rest is history, Your Worship. Yes, my junior is reminding me that the portion, the middle paragraph 96, the highlighted one, Your Worship, where the court is talking about abuse of power by ACC respondents and so forth. Remember, that is a matter where media personnel were taken to NHE offices when Mr. Airuru was unnecessarily arrested, and both the Supreme Court and the High Court had strong sentiments against ACC for doing that. In this matter, it's not different, and they have never learned, Your Worship. Now, I move with speed at page 18. Now, this matter of S versus Swanepoel, Your Worship, you must have come across this judgment. And it's very important because in that matter, Ms. Swanepoel has had convictions on fraud. She has pending cases, and the investigating officer said there are also some other new cases being added. Bail was refused by a magistrate of Windhoek. And look at what Justice Maritz and Damas have stated in the first paragraph. You say that we have also given consideration to the amendment of Section 61, that is public interest, Your Worship, of the Criminal Procedure Act, and the effect thereof on this application. We are mindful of the fact that even if the court were to consider that there is not a likelihood, but only a possibility that the appellant will abscond or interfere with witnesses, the court may still refuse bail if it is in the interest of public and the administration of justice to do so. It is our considered view that such a possibility can be appropriately addressed by the imposition of condition. This was an applicant with a history of conviction. So in other words, the state has the comfort. The state had the comfort to say, but this man, this lady, in the past, was found guilty. But even in that scenario, the High Court gave bail. And while we are there, Your Worship, may we refer to a very unfortunate statement made by the magistrate in that Swanepoel matter, Your Worship. Can I invite the court to exhibit H1? H1, Your Worship. And H1 at page 16 of that bundle. Your Worship, in the middle of the judgment of Swanepoel, the High Court criticized the consent magistrate of Windhoek when she retorted in her judgment. She said, now the court is left with this question: should the court grant the accused bail? Is she going to continue and work? Your Worship, in the middle, page 16. Paragraph? The third, Your Worship. The quotation. Page 16. Yeah. Is the third paragraph I'm reading.
I'm seeing that the paragraphs are numbered 4, 5, 6, and 7.
Oh, no. Oh, it's actually 116. Sorry. I think it was 116. Is the court with me?
116.
Yes, thanks, Your Honor. You see, now the court is talking about a most significant misdirection by the magistrate of Windhoek who was concerned, who ruled in that matter. Now she stated, now the court is left with this question: should the court grant the accused person bail? Is she going to continue and work, or is she going to continue committing similar crimes as she did? What did she learn from the previous conviction? Nothing. So the court has got a fear that should the accused be granted bail, she will go and commit similar offenses again. And then the High Court, the two judges of the High Court criticized the magistrate, and then the court at page 117, Your Worship, redirected the magistrate that in bail application you must first start with S versus Akeson, even after the amendment to Section 61 of the Criminal Procedure Act. And then you look at how deep are his emotional, occupational, and family roots within the country. What are his assets? What are the means that he has to flee from the country? How much can he afford the forfeiture of bail money? What travel document he has to enable him to leave? What arrangement exists or may later exist to extradite him if he flees to another country? How inherently serious is the offense in respect of which he is charged? The rest goes on, your worship. And at the bottom, then the court went on to discuss other considerations, and the High Court then listed them. And then you would see at the end, your worship, the court in that matter, with an accused person who has previous conviction of frauds and theft, granted bail in the High Court and attached conditions in lieu of or in alternative of refusal of bail. That is how important the High Court and the Supreme Court in our country respect liberty of an individual. Back to our heads of arguments, your worship, and I ended at page 18. If I can just invite court to go to page 18 of our heads of argument, paragraph 35. Again, your worship, we refer to that paragraph of Branco, which says, finally, a court should always consider suitable condition as an alternative to the denial of bail. Conversely, where no consideration is given to the application of suitable condition as an alternative to incarceration, this may lead to a failure to exercise a proper discretion. And then it goes on and says, the appellant has stated that under oath that he is prepared to report to the police station. Like in this matter, I discussed with Mr. Inambao. Your worship, may I refer you to a case that I didn't refer to? It's a case of Harry Simon versus the state. That case, your worship, I think it is in 2006 Namibian Law Report. I will ask my junior to file it with your clerk, your worship. The court stated that the last answer, favorable answer, extracted from the witness is final. So when I ask Mr. Inambao on a particular representing my client, as far as my clients are concerned, he's bound. He cannot, when I am in the High Court, when I have left this court, I have done my duty, I have cross-examined, I heard from sources that apparently behind my back, he was trying to retract concessions. He can never do that, your worship. It's not possible. So he can give whatever answers he wants to give to other counsel, but not to retract things he considered when I was cross-examining. It will be an irregularity for such a scenario to play it out in court. Then, your worship, let me go to page 19 of our heads of argument. And this is where this is a demonstration of how broken the arrest system in Namibia is. It's demonstrated in paragraph 36 of our heads of argument, page 19. And we say, a police officer or investigating officer of the ACC who blindly resort to arrest without the arrest being necessary and without exercising a proper discretion will be acting in a manner incompatible with the rule of law. Now, this judgment of Diane versus Minister of Police, that is a judgment delivered on the 24th of June 2022 by the Supreme Court of Appeal of South Africa. And look at what happened in that matter. Paragraph 19 say, 9, your worship, once the jurisdictional facts are established, the peace officer has the discretion of whether or not to arrest the suspect. However, if the suspect is arrested, and this is very important, your worship, a peace officer is vested with a further discretion whether to detain the arrestee or warn him or her to attend court. In other words, even assuming we have a warrant of arrest, there is a secondary, a further discretion and say, look, I found him, he came himself, I found him, he was just in a car accident, or he's cooperating. There is no need to arrest and take the person to court. You must still exercise a discretion whether you can simply just warn him and say, come to court on Monday. And then the court said, The arrest and detention of the suspect is but one of the means of securing the suspect's appearance in court. And Your Worship, can I invite the court to page 20 of our heads of arguments? It's a continuation from the same judgment, Your Worship. Because there, we highlighted deliberately what is very important, and in Namibia, this is a huge problem, Your Worship. The highlighted portion is that what emerges from the record is that both officers who effected the arrest did not know that they had a discretion. They labored under the mistaken belief that their obligation was to arrest their parents once it was reasonably suspected that she had committed a Schedule 1 offense. Corruption and fraud are Schedule 1 offense. There is this wrong misconception that once you tick off the list is murder, is whatever, and it's corruption or whatever, then you must just arrest. And then the second highlighted portion say, accordingly, that they did not exercise a discretion that they unquestionably enjoyed is beyond dispute. It must therefore follow that both the arrest and subsequent detention of their parent were unlawful. Indeed, counsel for the respondent was ultimately constrained to concede. I highlight again, these are not arrest proceedings. We are concerned with necessity of arrest. If the arrest was not in the first place necessary, it would follow that then the accused person must be granted bail because he was arrested when it was not necessary. That is the only reason we are referring to a number of those judgments. May I invite with speed the court at page 21 of our heads of argument, paragraph 37. And now, Your Worship, the Unengu judgment is important in our country on many aspects, legal aspects. Firstly, the highlighted portion in the middle of the judgment is that the court acco, in the middle of the quotation, Your Worship, the court acco should have further realized that the activity in court premised on the guilty of an accused threatens the presumption of innocence. That is the High Court Justice Ndou speaking, High Court of Namibia. And then, Your Lordship, paragraph 7, it cautioned magistrates not to be working with labels, like just a label, that fraud is serious or whatever and so forth. So it goes on Your Worship, on page 22, I have highlighted for the convenience of court the most important paragraph, but may I alert the court toward the end, the last paragraph highlighted, is exactly about the failure by the state in this matter in respect of some charges where the state considered that the charges are replete with mistakes and so forth. Judge Ndou has written about that in the Unengu judgment, and I want to move on without wasting time and invite the court to page 23 of the heads of arguments with argument number C5, Your Worship. Now, that is then the nature of the right and the nature of the inquiry. We refer the court to Alexander versus the Minister of Justice, 2010, Volume 1, Namibian Law Report, 328 Supreme Court. We rely on paragraph 101 and 102. That is the Supreme Court judgment on the right to liberty. Your Worship, I don't want to waste time, but paragraph 102 is important. It states, for the above reasons, I have concluded that Article 7 of the Constitution contains a substantive right to liberty of persons. So the rest of the judgment, Your Worship, is there to be considered. Then we move to page 24, paragraph 39. Again, Your Worship, we refer to S versus Dowsab, paragraph 3. Your Worship, this is a judgment of court that referred to Branco and Akeson. I had a privilege to author this judgment when I acted as a acting judge of the High Court. And in that matter, this will not come back to bite me. I refused bail, and the court refused bail because in that matter, the defense did not deal with the merits at all. The defense have disclosure of all statements, but refused to disclose what is the defense in that matter. So it never showed that the state has a weaker case because it refused, notwithstanding the fact that by that time the police docket has been given to defense. It was a case also involving violence. There were two murders in that matter. But what is important in paragraph 3 is this. The court is saying, due to the fundamental nature and importance of the right to personal liberty and freedom, any court confronted with a question whether or not to release an accused person on bail pending his trial should, irrespective of the perceived seriousness of the criminal charges faced, approach such a question fully conscious of the fact that persons accused of committing criminal offenses are constitutionally presumed innocent until proven guilty, and that bail pending appeal may only be refused if, after a proper assessment of all the facts, the court is of the opinion that the release of the accused shall be prejudicial to the administration of justice, and no bail condition will be sufficient and appropriate to address the feared prejudice to the administration of justice. So, Your Worship, there are several judgments about that. And at page 25, Your Worship, I refer to SAFU judgment versus the President of South Africa. You remember, Your Worship, that that is a judgment where President Nelson Mandela was unfairly treated in court when he was asked to subpoenaed in application proceeding to subject himself to cross-examination. Now, Your Worship, when Peter Elindi testified, there was no single question by the public prosecutor in relation to charges he's apparently facing. There were general questions on the agreements and so forth. There are several other matters that the counsel for the state did not suggest a contrary proposition to him. In those cases, whatever that was not disputed under cross-examination, with respect, the court must approach it that the state did not intend to dispute. And that is, those facts must be taken as common cause. I move to page 26, argument number C6, Your Worship. And Your Worship, it's not a small thing. It's not a small thing. There's one thing the court must be strong and robust in Namibia, is abuse of court processes and court procedures. We saw it happening before independence. Just right in the next building, Your Worship. When Mr. Aaron Mushimba and a certain Mr. Shikongo were put on trial, the investigating officer corrupted a secretary of one law firm to steal confidential information from the consultation and notes and content of the file, so that the state, when prosecuting Mr. Mushimba, was in a stronger position because they have stolen privileged information. Mr. Mushimba was convicted and sentenced to death. And the Supreme Court of Appeal in South Africa set aside that conviction and sentence of death simply on the basis that the state hands were dirty. They have no right whatsoever to resort to unlawful means when investigating crimes. So why do I refer to this? Accused persons were mistreated, were mishandled in this matter. I do not want to refer to list them. Accused persons testified, including more lamentably, invitation of the media to accompany people being arrested, Your Worship. No court of law will ignore such an irregularity. The other day we saw another person in the, it's a notorious public fact, Mr. Hengari being paraded. Luckily, this court doing justice, we heard that he's granted bail. If people are being harassed during arrest, are being mishandled during arrest, it's not the court's duty to assist such officers. Hence, we refer to the matter of Afrishua CC versus Watson, 2009, volume 2, SA 127 SCA, paragraph 39, towards the end of the quotation, Your Worship. It says that the principle underlying the par delictum rule is that because the law should discourage illegality, it will be contrary to public policy to render assistance to those who defy the law. And Your Worship, in our submission, my opening statement written, we handed it up already on the first day of this bail application. We refer the court to a matter of Pretoria, Portland Cement versus the Competition Commission in Namibia, in South Africa, where the members of the Competition Commission in South Africa invited the media and so forth and abused their power. Now, there is one judgment that is important in Namibia, and that is the judgment of the late Pio Tiek, a judge of the Supreme Court, who was unfortunately subjected to the grossest abuse through investigation. Your Worship, can I invite the court to the quotation from the Supreme Court judgment at page 27. In that matter, the police was biased because they thought they can only collect things information that is incriminating to the accused person and ignored information that was in favor of the accused person. Under paragraph 8.8, when the Supreme Court was acquitting Justice Tiek, who suffered a lot, and obviously we know that he is now late, he must have left this world a very bitter man because of what happened to him. The Supreme Court say, more disconcertingly, the video recording that was taken during the search and arrest was never presented before court, seemingly because it was irrelevant and of no use for the conviction of the respondent. So in other words, the police left out things that are in favor of Justice Tiek and only took things that are apparently relevant to the conviction. This is yet another instance of an unacceptable, selective, investigative shortcoming. And then the court, under paragraph 8.9, refer to the police and say that, toward the end of that paragraph, Your Worship, and say, any person accused of having committed any offense, whether that person is a judge or is holding a position of high office, should not be treated differently because of his or her public status. And it's usually in so-called high-profile cases that people are mistreated, Your Worship. Because when the WhatsApp qualified legal practitioners speak on social media platform, a person who, Your Worship, struggled to point out 4 directions in geography is now a professor of law and insulting lawyers, insulting judges because of subjective views in a bail matter. Your Worship, yours is to focus on dispensing justice, nothing else. So the court then went on paragraph 90. I do not want to refer to it. Then page 28, Your Worship. Then an important case. Your Worship, before I deal with that case of Freeman, may I refer you to the last judgment, Your Worship, on the second bundle I handed up today. Your Worship, page 53. The bundle that have General Nopoju, Hamnyera, yes. Your Worship, the case of Chamber of Mines of South Africa versus NUM 1987, volume 1668. And Your Worship, I am interested at page 54, the page of the law report is 690. I'm interested in paragraph D. Your Worship, in paragraph D, the sentence that starts, one or other two party between whom some legal relations subsist. Then the next sentence I will say, the principle that in this situation the law will not allow that party to blow hot and cold is a fundamental one. D, Your Worship, to just before E, on the left-hand side. The sentence that starts one or other, I will skip it, Your Worship. Then I'll start in the middle that says the principle. Is the court with me? Yeah. This is, and I do not want to waste time, is a legal principle that if you make a procedural election, you are bound by that election. Okay? The state in this matter, I took you through the charges. Some of the charges, in fact only one or two, refer to section 332(5) of the Criminal Procedure Act. The state knew from the beginning that Mr. Elindi, Peter and Malakia Elindi are being prosecuted because of what they did for a corporate entity. But the state, for purposes of this bail application, opted to charge them personally and did not rely on section 332 subsection 5. Your Worship, one newspaper reported that we argued that apparently company directors are never charged. We never made such an argument. We said, if you do not rely on section 332 subsection 5 of the Criminal Procedure Act, you will not seek a director of a company to be personally criminally liable. That was our argument. But what is important, Your Worship, is to refer the court to page 29. Page 29. Page 29, the first paragraph, the quotation there.
29, are we moving away from this?
Yeah, no. Yes, Your Worship, coming back to the heads. If you go back to page 28, you will see, Your Worship, that is a quotation from S versus Freeman. Yeah, just for your note, Your Worship, section 381, subsection 5, is exactly the same as section 3325 of the current Criminal Procedure Act. And it says that it was held that section...
338 of what?
The?
You made reference to section 338.
332?
Yes.
332, subsection 5 of the CPA, Your Worship.
Yeah.
So it is exactly the same as the old Criminal Procedure Act of 1955. That was 381 subsection 5, Your Worship. And the court said, and the court said that the full bench of this court expressly held that section 385 of the Criminal Code can only be relied upon by the prosecution if it conveyed to the accused in the charge that vicarious liability is relied upon with particulars thereof, as I have indicated. There is nothing to that effect in the charge. And I invite the court to look at the charges and so forth. And in the Supreme Court recently, on the section 332, in Minister of Finance versus Hollard Insurance, 2020 volume 1, NR, page 60, paragraph 6971. Your Worship, you look at the same page 29, paragraph 46. Justice Damasep write about it up to page 30. I move with speed to conclude, Your Worship. Paragraph 48 at page 30. This is now very important, Your Worship. Is the case of S versus Hugo, 1976, volume 4, SA 536, paragraph, appellate division. And already, all those of us that were at UNAM would already hear criminal law lecturer, Your Worship, highlighting that in fraud, precision is necessary. You must be precise with your charges. And that is the principle set out in that judgment. And when you look at that principle and look at the charges on which we came to this court in the bail application, those charges are a travesty of what a charge of fraud should be with respect. And at page 31, Your Worship, page 31, may I invite the court to look at footnote 35. It's the judgment of R versus Alexander, 1936, AD, at page 457. The court stated what is the charge and what must it contain. So when Mr. Inambao, a number of times, almost shedding tears, told us that they were under pressure, they worked until 2 in the morning, whatever, the charges are full of mistakes, that in future, Your Worship, they will be amended. The court is not a Sangoma. Does not know when and how they will change the charges. The court is working on the basis of the charges placed before court. Whether they are bad or good, they are bound by the charges we worked on during the bail application. I invite the court at page 39 of our heads of argument, and this is now very important, Your Worship, S versus Tekla Lamek and others, the so-called Teko Nuktek case. I just want to, again, this was one of the so-called high-profile corruption cases in Namibia. It was labeled, and accused person faced a number of charges, and they were, we know that history, they were never convicted of any offense. But to be fair to the Windhoek Magistrate Court, they were granted bail. If they were refused bail, it would have been a failure of justice. But what I'm interested in is Justice Liebenberg talking about the state poor way of framing charges. Your Worship, paragraph 5 over the page, and then you see at the end of that paragraph, Justice Liebenberg say, in the present instance, there was simply no reason for the state to indiscriminately patch together the charges in its current form. So it doesn't matter, the state has been warned in the past how to charge people and so forth. And then paragraph 54, it's then when Ms. Lamek, who was the Public Service Commissioner, was charged apparently for doing work while she is a Public Service Commissioner. If you can page, over the page at page 34, Your Worship, Justice Liebenberg say, disciplinary steps would ordinarily be the course of action to invoke, not criminal proceedings. Now, when my colleague, Advocate Lilungo, was cross-examining Ms. Hamukwaya, Your Worship, you must have noted and possibly struck by this cross-examination saying, you did not do a proper due diligence. That means Mr. Lilungo was not suggesting mens rea in a form of intention. He's either suggesting incompetence or negligence. But what are they doing in criminal court? So the same can be said, and using the Tekrarame case, Your Worship. Then, Your Worship, indeed, we then address fatal concessions that were made by investigating officer in Nambao. May I make it clear? These men, just like other men and women in uniform, are doing a very important public duty. So when they stand up and subject themselves to cross-examination, that is exactly why they are there. So, our cross-examination is not an attack on their duties, but we have taken an oath, some of us, to defend the Constitution and to do our work without intimidation by anyone, including even Livade. We can do our work. So I have listed all those, Your Worship. And then, Your Worship, I want to conclude with this. The conclusion is there. By referring you to the case of S versus Paulus. S versus Paulus, Your Worship, you must have read that judgment. I know, Your Worship, you are a passionate case reader. And in Exhibit H1, Your Worship, the moment one reads this judgment, I was again involved, Your Worship. It's reported as S versus Paulus,
One at one page.
66. S versus Paulus. 2011, Volume 2, NR 649. Your Worship, at the beginning, that person was charged in contravention of Section 31, subsection 1 or A of the Anti-Corruption Act. You would then see that at paragraph 4, at the same page, the judge's quotes from the defense lawyers' heads of arguments, and you would see, Your Worship, in paragraph 4, the judge says, Mr. Namanja, who appeared on behalf of the appellant in his heads of argument, submitted in this regard. Then he quoted the arguments by the defense counsel. There was a glaring omission on the part of the land magistrate to specifically analyze the evidence with a view to finding that the state proved all elements of the charge, including but not limited to the element of a subjective intention to receive gratification as an inducement and the element of inducement itself. Then Section 35, subsection 1A of the Anti-Corruption Commission Act, with minor differences, is the same as South African Ordinance number 17 of 1939. Then, Your Lordship, the law is there. That, look, where they are saying, for instance, my client is charged with apparently giving a reward, you must read evidence that proves that, yes, Mr. Elindi, on a particular date, offered or gave this particular amount to a specified person. And it is an element of that offense to describe that person was being induced to do what. And though that is the law, it's not about just putting up words, and there was absolutely no evidence whatsoever on the merits of those charges, and the charges are bad. And I end, Your Worship, with one important thing. It's a difference between criminal fraudulent misrepresentation and commercial misrepresentation. Luckily, Your Worship, if you go to Exhibit H1, page 183, Your Worship. That is a judgment of Dawn Adams versus Van der Berg and others, judgment delivered on the 20th of November 2018 by Justice Prince Law. Your Worship, if I invite the court to go to page 211, paragraph 89 of the judgment. The court stated, 211, paragraph 89 of the judgment of the High Court of Namibia. It stated that, referring to Transbank Africa versus Freisch, 1977, it says, a party who seeks to establish the defense that the contract which he entered into is voidable on the ground of misrepresentation must prove the onus being upon him. In this case, because it's a commercial context, it's NAMCOR and the state actually must prove that a representation was made by the other party in order to induce. So in other words, it must happen before the act, before that person act to his prejudice, to induce him to enter into the contract. That representation was material. In other words, it's not ever, even if it is wrong, that party must show that it was material. Number 3, that it was false in fact. Number 4, that he was induced to enter into contract on the face of representation. Now, with respect, I have Mr. Inambao said he never did any course in contract and commercial, yet he's investigating commercial transaction. He did not, with respect, have any knowledge whatsoever how fraud could be committed. His version, and I took note, can you distribute that? His version went from fraud committed somewhere in May to 2021 to prior to 8th of May to after 8th of May to the 19th, and I took note. His version was contradictory. This is how his version was. I took note. This is exactly how he was. He threw us around. He even said at some point the fact that Ms. Hamukwaya was already on the bank, Enercon bank, that is arrangement or undertaking. Then he said the supply, petroleum product supply agreement was legitimately concluded. Then at some point he said, no, the dynamics were all these were good commercial transactions. Something only happened after bribes were paid. I have never seen where fraud can happen in reverse. And then the warrant of search, on the basis of which my clients were arrested, it says, Your Worship, the warrant of search says, yes, arrest, Your Worship. Your Worship, in H1, the warrant is at page 1. The magistrate who issued the warrant, her period, she stated these offenses were committed. If you look at page 2, Your Worship, she said it's between the 8th of May, 2022, and 12th of December, 2022. That's what the magistrate was told. But in court, remember, misrepresentation must happen before a victim act to his prejudice. But in this matter, it's an impossibility because it's common cause that it's NAMCOR that approached my clients. My client never offered anything. In fact, it was my client that was induced to enter into contract. So they must search for a misrepresentation in NAMCOR's communication because it is NAMCOR that approached my client. In any way, Mr. Inambao killed the state case, overkilled it actually, when he stated, actually, the dynamic until the 19th of July were good. So there was never misrepresentation. And he found himself also saying, Mr. Mulunga is a victim of fraud. All that, Your Worship, you have those facts on your notes, Your Worship. And then the biggest failure is this, is the case that in fraud, commercial fraud, if you accept to continue with the contract, you can never rely on fraud. And that is at page 180, Your Worship, 180 of Exhibit H1. That judgment of Bowditch and Peel, the last 5 lines, page 180. It says, Your Worship, a person who has induced, who has been induced to contract by the material and fraudulent misrepresentation of the other party may either stand by the contract or claim rescission, which is cancellation. It follows that he must make his election between those two inconsistent remedies within a reasonable time. after knowledge of the deception, and the choice of one necessarily involve the abandonment of the other. In other words, if you choose to continue with the contract, you can never come back. You abandoned cancellation or allegations of fraud. But here, Mr. Chiwana Ndeunyema, in September 2023, said so loud to everybody that this contract is intact, valid, and binding. That is more than a year after that. Yet people are in court on fraudulent misrepresentation. NAMCOR is bound by that agreement. I know at some point probably they cancelled it, but this just shows that with respect, this case brought to this court with much fanfare is weak and it will collapse. It will collapse in the goodness of time. And I'm talking about on behalf of my clients. It is in those circumstances, Your Worship, that I submit, Your Worship, I have already demonstrated how my clients are charged with wrong offenses and so forth, that first and second applicants made out a case, a very good case, to be released on bail. If, Your Worship, you have some fear, like Branco case is saying, Dowsap case is saying, you then, the next stage is then to look at appropriate conditions that I discussed with Mr. Inambao. Mr. Inambao stated administrative arrangements will be made for my clients to report if that is a condition, and he said, Your Worship, he would also be happy that an order is made that my client do not apply for any traveling documents. In view of the weakest nature of the case, my primary asking is that accused person be warned, Your Worship. In the event of the court finding that warning would be inappropriate, then, Your Worship, bail in the amount of 50,000 like the other two accused persons should be fixed with conditions, Your Worship. I suppose that the same public interest has always been there when the two accused persons were granted bail. Your Worship, that is my case for the first and second applicants. If there is anything that I left out, Your Worship, I refer the court to our written submissions at the beginning. They are useful again. And the written submissions. Unless the court has a question, those are my, oh, Your Worship, I forgot. I have a specimen indictment if somebody is being charged in official capacity. I took, Your Worship, from a very good criminal writer, and I took out so that, Your Worship, you can see yourself that the state made an election to come with half-cooked charges, bad charges, and those charges, with respect, when considered during bail application, they cannot pass the test in Unengu. I hand up those specimens for the court simply to say how one frame and formulate charges, particularly in the area of fraud. Those are my submissions, Your Worship.
It's in order, Mr. Namanje.
Yes, as the court.
We can proceed.
Your Worship, does the court need maybe a short adjournment, or
Yeah,
can
I
I
think so.
just proceed?
5 minutes.
5 minutes or 10 minutes?
We can have a 10 minutes.
Please, the court, Your Worship, just to rearrange the setup.
Yeah.
Please, the court, Your Worship.
The court then briefly adjourns.
Your Worship, before I proceed, my colleague would like to address the court, to refer the court to one authority which is attached to his heads of argument. Please, the court, Your Worship.
As the court, just to
The
refer you
authorities are before court, yes?
and the General Nopoju Amnyeras bundle, I call it, page 52. Page 52, Your Worship. It's the academic article at page 52 on the role of the judiciary in a society unsettled by crime and social, economic, and political strife. And what I'm referring to, Your Worship, is just that seminal statement in 1942 by Lord Atkin, stating that in the middle of the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war and in peace. So in other words, Your Worship, even if the society we are concerned with the crime must be fought effectively, but fairly and in accordance with the law. The law does not sleep. It speaks the same language in war, against crime, and in peace. The article is there. It referred to a number of principles, Your Worship, so that the judiciary, particularly in digital age, does not stray away from established principles of independence and professionalism. As the court, please.
We can proceed.
Yeah, thank you, Your Worship. Your Worship, the submission on behalf of the fourth and fifth applicant in respect of this bail application will be very brief. I will be very brief simply because I think as far as the authorities and the case law and the jurisprudence as set out by Mr. Namanje, they will definitely apply mutatis mutandis to my clients, to accuse number 1 and accuse number 3. So my heads of argument, or my submission rather, I will be referring His Worship to Exhibit E1. Exhibit E1, which was handed up when I made an opening statement. I will also refer to Exhibit E2, that is the bundle containing documentary evidence in support of fourth and fifth application for bail. And then E3 being the personal circumstances of fourth applicant, and then E4 being the personal circumstances of fifth.
You are referring to E3 and E4.
E3 and E4. Exhibit E3, that is for Mulunga, and then E4 for Jennifer Hamukwaya. Please,
We don't have E4 and E3. Can you just confirm?
It was handed up during the hearing, Your Worship. State?
It's only E1 and E2, not E3 and E4.
It's E3, but I'm not aware of E4.
Yes.
Yes. Can you check there whether you have E4?
What is E4?
My documents. Advocate, what is E3 or E4? Councils, as officers of court, can you just, yes.
My Lord, Your Worship, if I can assist, based on the list of exhibits that we have, which we have been preparing on an ongoing basis, Exhibit E3 refers to the personal circumstances, including assets of the fourth applicant. However, there is no recordal of Exhibit E4. Yes.
Please, the court, Your Worship. So, of course, with regard to the personal circumstances of Jennifer Hamukwaya, we refer to the evidence in chief. So I will address the main issues, Your Worship. First, I will make a short, submission in respect of the case we are dealing with, and then number two, I will deal with the investigation by the Anti-Corruption Commission of the present matter, and whether it was justified or in public interest. And then number three, I will deal with the charges in passing against the fourth and the fifth applicant. And then number four, I will deal with the evidence in passing as well, because the record is clear. The evidence in chief, most of which was not challenged or controverted during cross-examination by fourth and the fifth applicant, and then the law applicable to bail, and then the objection to bail, as well as the jurisprudence applicable thereto, and then the conclusion. So, Your Worship, this court is seized with what has been termed fuel rot. I think fuel rot taken from the so-called fish rot case. Your Worship, like what we have seen in this court, there is nothing, no such thing as a fuel rot. It's just sensation. I think either some obscure forces trying to create some kind of attention and public outcry through social media, through print media. I will say so because of this, Your Worship. Evidence was led by my clients who are ex-employees of NAMCOR. Fourth applicant is being charged for pretending to have an authority to sign an asset purchase agreement. That is the main charge. When I asked Mr. Inambao, who is the chief investigator, who investigated this matter, I asked him, Mr. Inambao, why are you charging Mr. Mulunga, fourth applicant, for not having authority when the schedule of authority, clause 4.2, which document you had when you investigated, gives him the authority to do? He agreed with me, Your Worship. He says, yeah, it's true, Mr. Mulunga had authority to sign any agreement, even to the amount of 500 million. Then I proceeded, I asked him, Inambao, do you still persist with this baseless charge? Why don't you withdraw this charge against my client? His answer, his song from day one until today was conspiracy, fraud, theft by false pretense, just allegations. That's why, Your Worship, I think I ended referring to him as a storyteller, not an investigator. And then I asked him, Your Worship, Mr. Inambao, is there any reason why we don't have the bank statement of Mr. Mulunga, fourth applicant, and Jennifer Hamukwaya, the fifth applicant? Did you have sight of those documents during your investigation? He said, yes. Why don't we have them? Because we have so many bank statements. The answer was, oh, we are still studying them since 2024. Studying a bank statement since 2024. Oh, did they receive any money from anyone?
No, they did not receive any money. But conspiracy, fraud, same song. That is the fuel rot we are talking about here. And then, with Mr. Jennifer testified, pardon my, Your Worship, the fifth applicant, Jennifer Hamukwaya, testified, say, look, whatever I did, I comply with the internal policy of NAMCOR. And then when I left NAMCOR, no single disciplinary action was taken against me for violating those policies. I asked the Inambao, when you look at those policies, is there any provision for criminal prosecution in the event of non-compliance? He says, there is no such, but if a crime is committed, we have the power to arrest and prosecute. And then, with regard to the issue of Mr. Mulunga, the allegation of gratification receiving a motor vehicle from a certain Victor Malima, I asked the Inambao, who is the owner of that car? A certain Hileni Kamati. Where do you get that evidence? Oh, I went to Natis. Inambao, where is the proof of registration or certificate of registration of that car? Why you did not provide to the court or to the state? Inambao, you went to Miss Hileni Kamati. Yes. Did you take a statement from Miss Kamati? Yes. Where is the statement? Nothing. Why are you hiding that information in Nambao from the state and from the court? Nothing. As I said, the thick judgment referred to by my senior in the Supreme Court, when you are an investigation officer, you have a duty to ensure that every evidence, including evidence exculpating a suspect, must be brought to the attention of the court. Inambao failed in that duty. Inambao is not a reliable witness. He's hell-bent to keep innocent people behind the bars. That he has shown through his evidence contradicting himself. Your Worship, the record will show that he told the court, I did not, when I asked him, Mr. Mulunga is a victim of witch hunt and is an scapegoat. He says, I never met Mulunga, I never saw Mulunga until I went to arrest him. Your Worship, later on he says, yeah, myself and another colleague who used to follow him when he was driving the car in question. This type of contradiction and retraction clearly shows that the evidence of Mr. Inambao must be taken with caution. Actually, it should be disregarded as it applies to my clients, to fourth and fifth applicant. And then, Your Worship, if you look at the investigation by the ACC, in my opening remarks, I made submission that this investigation was not justified, neither was it in...
You are saying the evidence must be disregarded.
No,
in terms of what law?
No, Your Worship, I said, when you look at the credibility, because the court, when assessing or evaluating the evidence, you have a discretion to look at if there are internal contradiction, then you can use those contradictions against the witness, because that's what the law says, Your Worship. Please the court, Your Worship. Please the court, Your Worship. And then we say the investigation were not in public interest, and I referred his Worship to section 18, subsection 2, Roman 3, which says that, that section says that, it says that when
to decide whether an investigation is warranted, the ACC must take into account following factors, and I will refer to Roman 3, whether or not the Section 18 of the ACC Act, 18.1c, 18.1c, and then Roman 3, whether or not the conduct or involvement to which the allegation relates is or has been subject of investigation or any action by any other appropriate authority for purpose of any law. That's what one of the factors to be taken into account. We say so, Your Worship, because we have demonstrated that the subject matter of investigation by ACC before this court, that is the fuel supply agreement and as well as the asset purchase agreement, we have demonstrated those issues are already seized by other authorities. That is litigation before the High Court, liquidation. I'm not sure, yesterday there was a judgment by Honorable the Deputy Judge President in terms of which Enercon and Petroleum indeed were liquidated by the same court. And then we also have other disputes. For instance, fourth applicant pending before the labor court. Exactly verbatim, same subject matter. And then we say ACC ought to have considered those pending proceedings or finalized proceedings to save time as well as to save public funds. And then we say the ACC, if you look at, Your Worship, if you look at the record, the ACC is now a debt collector, is trying to assist NAMCOR to collect fuel money, contractual claims, is now trying to lend its hand to NAMCOR to deal with ex-employees because they have since left NAMCOR. Your Worship, they know. They can't bring back Jennifer Hamukwaya, fourth applicant, and bring her back before a disciplinary committee. It's too late. She left. She's no longer an employee. And then what they do, they're now trying to use anti-corruption commission. They're trying to use their investigator, in this case, Nambao, to ensure that this innocent mother of 3 minor children who has moved on is now continuously persecuted. We submit this shall not be allowed to happen because, Your Worship, you see in the Hailulu judgment, which is referred by my colleague, at page 21 of the same judgment, it says that the ACC may conduct an investigation itself or ask another appropriate authority to for appropriate action. The use of expression another appropriate action, in my view, this is Deputy Judge President, no, the Deputy Chief Justice and the current Judge President of the High Court. He says, in my view, this implies that not every complaint will assume criminal character. The infraction involved could be an administrative character, and internal disciplinary measures could be more appropriate. And then he carries on, he says, an investigation could also be more appropriately dealt with internally and the facts submitted to the ACC for consideration. We say, if the ACC and Mr. Nambao, if they could have done their work properly, if they could have consulted the executive at NAMCOR and the board, and also spoken to the suspect or the accused person before you, Your Worship, we wouldn't be sitting here. When Nyambali was asked, why did he not talk to the accused person before arresting them? He said, there is no law which obligates me to do that. He says that, Your Worship, that's wrong. It's a wrong proposition of the law. It's a wrong proposition of the law because the ACC is a creature of an act of parliament. It's an administrative body. And they are not above the law. They are bound by Article 18 of the Namibian Constitution, which codifies the tenets of natural justice, i.e., to give an opportunity to any affected person to make a representation before their rights is taken away or affected. Now, Your Worship, much has been said, and my colleague has spoken about the abuse of power by the arresting officer in this matter. We have heard the horrendous stories about phones being taken, accused person being forced to give PIN codes. As we sit here, the state has refused to surrender those private property. They considered that there was no search warrant in violation of Article 13 of the Constitution. Your Worship, the state is very powerful, but they must comply with the law. The state, you cannot have police officers arresting people, going through correspondence, email correspondence, WhatsApp correspondence, medical prescription of people, bank account without judicial oversight. Like my colleagues stated, the state's hands are dirty, and therefore they cannot invoke public policy or public interest to deny my clients bail. Because before you invoke public policy or public interest meaning respect for the law, our constitutional values, the state has a duty to comply before they can come and invoke the same rights. Now, Your Worship, after a brief submission on the ACC investigation, as well as the the preliminaries on the fact that the investigation in question were not in public interest, nor justified. Let's move to the issue of the charges in passing against Mr. Mulunga. Mr. Mulunga.
Maybe before you move, it's
yes.
already past 1300 hours. The court will adjourn for lunch. We meet at 4:15.
That's in order, Your Worship.
Yeah.